In August of 1928, May Donahue and a friend decided to visit the Well Meadow Cafe in Paisley, Scotland for a pear and ice, and for May Donahue, an ice cream and a bottle of ginger beer. Everything was paid for by May Donahue's friend. Ladies, what would you like?
I would like a pear and ice.
I would like an ice cream and a bottle of ginger beer, please.
Here you are, ladies.
Oh, thank you.
Thank you.
Unfortunately for May Donahue, she got a little more than just ginger beer. As she came close to finishing out the bottle, out popped a rotting snail.
And this bottle of ginger beer tastes funny.
Oh my goodness, May.
Oh my goodness. Oh my goodness. Waiter, waiter.
Lordy be, ladies, I have never seen the likes of this before. House of Lords, the proposed issue for the pursuer is a personal injuries action of whether on or about the 26th of August in the Well Meadow Cafe, Well Meadow Place, Paisley, the pursuer sustained injury caused by the fault of the defender or his employees. Pursuer Mrs. May Donahue, formerly residing care of McAllister, 49 Kent Street, off London Road, Glasgow, and now residing at 101 Maitland Street, Cowcadence, Glasgow. Against defender Mr. David Stevenson, Junior Aerated Water Manufacturer, 5 Glen Lane, Paisley. This is a civil action between two individuals. It is not a criminal prosecution by the state. The facts are simple. On the 26th of August, Mrs. May Donahue was in the Well Meadow Cafe in Paisley with a friend who bought her a drink. Mrs. Donahue had consumed part of a bottle of ginger beer as part of an ice cream float. At that point, all was well. However, when the rest of the bottle was poured into her glass, out floated what appeared to be the rotting remains of a decomposing snail. That caused May Donahue to feel very unwell, or so she claimed. She sued the manufacturer of the ginger beer, David Stevenson, and won. Then the judgment was overturned. We are here today so the House of Lords can rule on the pursuer, May Donahue's, appeal of the overturned judgment.
May it please your lordship, Lord Atkin, I now have the opportunity to address you on behalf of the pursuer, May Donahue. The decision is for you to decide. The reasons why you should decide in favor of May Donahue are as follows. The fact and truth is that the incident happened as May Donahue alleges. The incident was caused by the fault of the defender, Mr. Stevenson, and or his employees, whom did not take reasonable care. May Donahue sustained injury caused by that fault. That is clear from the evidence of the doctor's statement and hospital stay. Finally, the figure of 500 pounds is a maximum, and it is a reasonable total. Thank you for your attention.
May it please your lordship, I now have the opportunity to address you on behalf of David Stevenson, the defender. The reasons why you should grant a judgment in favor of the defender are as follows. Number one, the pursuer failed to prove that the incident happened as May Donahue alleges. Number two, the pursuer failed to prove any fault on the part of the defender, Mr. Stevenson, and his employees. And number three, May Donahue failed to prove that she sustained injury caused by the fault of the defender. Finally, in relation to the damages, I have very little to say. My primary position is that there should be no award at all. If you are against me on that, then any award of damages should be no more than 50 pounds. Thank you for your attention.
Gentlemen, there must be and is some general conception of relations giving rise to a duty of care. of which the particular cases found in the books are but instances. The rule that you are to love your neighbor becomes in law, you must not injure your neighbor. And the lawyer's question, who is my neighbor, receives a restricted reply. You must take reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbor. Who then in law is my neighbor? The answers seem to be persons who are so closely and directly affected by my act that I ought reasonably to have them in contemplation as being so affected when I am directing my mind to the acts or omissions that are called in question. A manufacturer of products which he sells in such a form as to show that he intends them to reach the ultimate consumer in the form in which they left him with no reasonable possibility of intermediate examination, and with knowledge that the absence of reasonable care in the preparation of putting up of products will result in an injury to the consumer's life or property, owes a duty to the consumer to take that reasonable care. A man has a duty to conduct himself in such a way so as not to harm others, where a reasonable man would have seen that such harm could occur. The principles of this judgment still lie at the heart of modern common law, of negligence and consumer protection. The case was returned to Scotland for the Court of Session to apply the ruling to the facts of the case. In the event, David Stevenson died within a year of the decision, and his executor settled out of court for £200, well short of the original claim of £500, plus legal costs.